Our next point is legal notice. So first question is, what is legal notice? A notice is an announcement to inform someone about something. In the world of law, notice means to draw someone's attention to some matter or to inform about something. Therefore, it can be said that a legal notice is a notice under the obligation of law. It could be a notice that is required by law to inform someone about some violation of law, to take proper action, or to compensate such violation similarly. A legal notice could be given to a party to inform them about the legal action taken by another person. For example, it could be a notice informing that a party is going to purchase a certain property or certain claims and demands in a legal format. Therefore, it can say that legal notice is the legal concept describing a requirement that a party be aware of legal process affecting their rights, obligations, or duties. And a legal notice is formal written information, notification, or warning about a fact or invitation to the concerned person for attending the meeting. According to Section 3 of the Transfer of Property Act 1882, a person is said to have notice of a fact when he actually knows the fact, or when, but for willful abstention not to do something from an inquiry or such which he ought to have made, or gross negligence, he would have known it constructive or implied notice. If you are going to explain Section 3 of the Transfer of Property Act 1882, we will observe there are three kinds of legal notice. So, there are three kinds of legal notice. First one is actual notice, that is express notice. When a person acquired actual knowledge of a fact, in the law or in the section, you will see that it is written when he actually knows. When a person has acquired actual knowledge of a fact, it is the handing over of notice in person in written form with signature required to a party in a lawsuit. Sometimes actual notice is called a direct notice. Next one is constructive notice, that is implied notice. When the subject matter is not specifically informed but very probable to know by an ordinary person, unless there is intentional absence or gross negligence. In the law or in the section, it mentioned, but also when he should have known. Therefore, according to the reasonableness, the parties should have known it. Another part is notice to the agent. When the information is given to the agent and duly received by the agent, whether actually it is passed to the uh, principal or not. That means information received by or given to the agent in the course of the ordinary duties, whether the communicate it to his principal or not. Next, there is another kind of legal notice, that is public notice. It is important to provide an information to the public regarding certain types of legal proceedings or government related activities. A public notice or notice of intent is information given to citizens of a governmental entity regarding government related activities. Public notices have traditionally been published in specified government publication and in local newspaper, a common source for community information. But please remember, the section of Transfer of Property 1882 indicates there are three types of notice, that is actual notice, constructive notice, or notice to the agent. And public notice is a notice. Obviously it is a notice, but it is only used for giving information to the public regarding certain types of legal proceedings or government related activities. Here I'm going to give a format of legal notice, but before giving a format, you have to know that essential elements or factors of a valid notice. So for a valid notice, there are some essential elements or factors. First one is signature. The notice must be in writing and signed by the proper authority. Only the legal authority should serve the notice. That's why we already mentioned here the advocate's name, details, address, contact number, email, etc. And before that, you have to write the name of the legal notice, that is author description, or description of the legal notice, that is legal notice against deed agreement. And next point is dated, obviously proper time, date and place. No, the notice must be served in proper time. It should be circulated according to the rules and regulation. The time, date and place of the meeting must be stated in the notice. That means date is very important part for a legal notice. That's why we mention date here also. Next part is by registered post with AD. AD means acknowledgement due, and you have to mention this. Without acknowledgement due, it will not be a legal. It cannot be considered as a legal notice or lawful legal notice. Next part is subject legal notice. It is optional. You can include it or not. It depends on you. And then you have to write down the name, the person to whom you send this legal notice. Here I mentioned to A. A is the person, managing director, ABC Company Limited, and you have to provide the address also. This is the main part, or you can explain it as a body of a legal notice or a content of legal notice. And in this part, you have to identify any relevant material or right which you claim has been uh, intended. The notice must be short in size. You should identify the specific terms and condition which was settled between the parties but did not fulfill by any one or any parties. It should be clear, simple and easy. An explanatory statement should be sent with the notice. That means why you want to identify that the terms and condition of the contract did not fulfill by any specific party. For that, you have to start with having instruction from and on behalf of my client B, son of age, occupation, NID, address, all details, and I do hereby serve you with the following legal notice. And then you will specify all the terms and conditions which was not fulfilled by the party. Here I mentioned as A. And when you write down all the parts, please remember a notice should be served to the proper person who are entitled to attend. His full name, contract details, including full postal address, telephone number, etc. Proper person is very important. And you will write down all the terms and conditions, or you will write down the arguments why you feel that it is not fulfilled, then you should write down the next para, that is, I therefore through this legal notice call upon you to A within the period of 15 days from the date of receipt of this legal notice. Here you can inform or you can give 7 days, 30 days, depends on the circumstances how long it will need. failing which may which failing which my client has given me clear instruction to file legal proceedings against you in the competent court of law, as well as before the other authorities. In that event, you shall be fully responsible for all cost, risk, and responsibilities, which you please note well. That means you informed him, or you will inform him, that you will go to the court if he will not reply you. Then a copy of this legal notice is retained in my office for record and for the necessary action. So it is just inform him that I will retain this notice. And here I indicate, or I mention that my office, this my means advocate. So I already informed here that this failing which my client has given me clear instruction to file. So this my means advocate. That's why you have to put the signature, advocate signature, name, seal, etc. And the last part is copy to. Copy to means if you want to give anyone without a, if you want to send this legal notice anyone without a, then you can write down the name. It will be good, it will be better if you can provide the name and his occupation and his relation, then that will be fine also. So that's all for legal notice, and it is a format of legal notice.